Well, good morning, Brian. Thank you once again for taking time out to share with us your insights into changing legislation, particularly this year. I think there's a couple of bits of legislation which are going to affect our members and affect estate planning in particular. And it's something I think we need to be aware of, and it's becoming increasingly important that advisors are up to speed with what's going on. So Brian's, if you haven't been on one of these webinars before, Brian's been with us running our estate planning series for a couple of years now. And this is the first for 2017. I think we have another 3 for later on in the year. So Brian, good morning, and thank you once again for the time taken out to share with us.
Good morning, David, and thanks very much. And welcome to 2017, although we're almost a quarter of the way through the year. And I should or could claim credit, but I can't. It's actually very appropriate that the first session that we're doing this year happens to coincide with the change of legislation. As David mentioned, an amendment was passed and the new law is effective with respect to enduring powers of attorney and the various changes, which the rationale behind was to make them easier, to make them more accessible to people, and just to streamline the whole process. So as far as the presentation today, what I thought I'd do is a quick snapshot or a review of the current legislation, the current format, the current emphasis, the benefits and the needs for enduring powers of attorney, and then following on from that, just an update on the changes to the legislation, what it means, and more importantly, from your point of view and from your client's point of view, the benefits, the changes, and how the legislation and the effect that it will have on your clients. So just a bit of a quick overview, and again, and I excuse me if you know this, but just to recap what an enduring power of attorney is. It is a legal document which enables an individual to appoint a manager to look after their affairs, both with respect to property, and by definition, property means your assets, and personal care and welfare. And that comes into effect when either through incapacity, illness, or need to, you are unable to do so yourself. So why do you need an enduring power of attorney? Some of you may have seen these figures before, but if we look, for example, at the injuries in car accidents, and this was what, 2013, there were almost 12,000 people injured in car accidents. Those that unfortunately passed away, and excuse my black sense of humour, were the lucky ones. They had finality. They had direction, they would have had a will, there would be a mechanism in place to look after or to continue to manage or control their assets. But what about those clients that you have that were injured in accidents or had a need to make a claim under a TPD policy or a critical care replacement income policy? If those people did not have enduring powers of attorney in place, then there is a serious issue regarding accessibility, making the claim process. So it's all about ensuring that the good work that as advisors you do is able to be transferred so that the benefit does reach the appropriate people. So as far as a bit of a background or where the original legislation was changed back in 1998, people often get confused between powers of attorney and enduring powers of attorney. So prior to 1988, you were able to complete a power of attorney. With that document, I, for example, could appoint David as my attorney so that if it was necessary or appropriate to, David could look after me from a financial point of view. He could take care of the running of my assets. However, that changed in 1988 because a property attorney is only able to act whilst the person who has given them that authority has their capacity. So the change or the introduction of the Protection of Personal Property Rights Act, or PPR as it's known, enabled the situation to be covered if, through circumstances, I lost my capacity and I still wanted David to act for me. So what the enduring power of attorney does, it covers that situation if I no longer have my capacity. And I'll talk about the various options that are available. So the two types, certainly the most, well, I shouldn't say the most important, but the first one is the property enduring power of attorney. And as I mentioned before, property by definition means your financial affairs. So you've got clients, you might be a mortgage broker, you might be a risk advisor, you might be a financial advisor. All of those clients have needs with respect to the management of their financial affairs. For example, you are currently arranging a loan agreement for your client. The application needs to be signed. Unfortunately, one of the applicants has suffered some form of incapacity and can't sign that document. Unless there is an enduring power of attorney in place, then the other spouse has no legal right or no legal ability to sign on their behalf. So come drawdown time or settlement time or the whole mortgage application process, that potentially could stall the whole transaction and result in that sale or the purchase or the transaction failing. From an insurance point of view, if you are selling living insurance, come claim time, if that individual has not passed away but has suffered incapacity, illness, or is unable or unwilling to sign the document, being the claim form, then how will that claim be processed? The insurance company will require the claim form to be signed. That will need to be signed by the owner of the policy. If that owner cannot complete the declaration or complete the claim form, then the claim won't proceed. So although you might think enduring powers of attorney are not appropriate, not necessary, I would challenge you to look at your client base. Look at those clients that you are working with. Every one of those should have an enduring power of attorney. There potentially might be the need where something arises, something needs to be signed. Who will sign if the client can't sign themselves? So the document deals with the ability for the individual to appoint somebody to act for them if through circumstances they can't do so themselves. You might think that this is quite all-encompassing and you're giving away control or you're giving away the ability to dictate what happens, but you can put limitations on the document. The enduring power of attorney can be effective immediately and able to be used at any time and is not revoked if you lose your mental capacity. So that's the first option that the client could elect. The second option is that the document is only effective in the event of mental incapacity. And there is a difference between the property and personal care and welfare as to when it becomes effective, but I'll talk about that later. With respect to the attorneys you appoint, you can appoint an individual, you can appoint joint attorneys, or you can appoint joint and several attorneys. So clearly, sole is one person appointed, joint means two people, and if it's joint, both have to sign, and if one can't sign, then the other does not have the authority. So it's not that we don't, but it's rare that we have joint attorneys because of the potential issue. If one can't sign, then the other can't, because under the joint requirement, both have to sign. So joint and several, this is where you appoint two and either or can act. And we always recommend that there is a successor attorney appointed. So as far as the property attorney, they have to look after and work in the individual's best interest. They have to ensure that whatever they do or whatever they undertake on behalf of the donor is for their benefit. They have to encourage the person to use and develop whatever capacity they have for looking after their own affairs. They should always consult with others, and where there is a welfare guardian, consult with that welfare guardian. With respect to personal care and welfare, enduring power of attorney, this is the ability for an individual to give their attorney the right to make decisions with respect to their care, their health, their well-being. Unlike the property, you can only appoint one person as your personal care and welfare attorney, and that must be a human. It can't be a trust company. The personal care and welfare EPA covers decisions such as care and treatment, what home, what hospital that the individual might go into. From a personal point of view, recently we've had to put my mother into care in Christchurch. I act as her personal care and welfare attorney, so I had to sign her admission forms. I'm actually down in Christchurch next Friday, so I will be meeting with her and with her doctor just to review her medical care, her treatment and that. She has been certified, because she's got, unfortunately, onset dementia, she has been certified as having lost her capacity. Now that that situation has arisen, the authority now comes into play, so I am making those decisions with respect to care, with respect to her well-being. The assessment of mental incapacity, it has to be by a specialist, so it needs to be by a registered GP or a geriatrician or a person that specialises in that type of care and treatment. The attorney cannot make decisions for the donor regarding certain aspects, that being marriage, adoption, or the refusal of medical treatment that is designed to prevent serious health damage, or other than treatment that is not life-threatening, or to stop treatment that would prevent a life-threatening situation. Again, there are obligations on the welfare attorney. They must protect the person's well-being and have their best interests at heart. They must, wherever possible, encourage that person to use and develop what capacity they do have. When they are incapacitated, if they can, encourage that person to act on their behalf, help them to be part of the community, consult with the person or other persons that they think are appropriate, and consult with the property manager if there is one in existence. In both situations, though, the attorney, their prime objective, or they should always act in the best interest of the person who is giving the authority. So the donor is the person who creates the document. It's the attorney's obligation, or it's their requirement to act in that donor's best interest. With respect to special conditions or conditions that you can put on the document, you can stipulate that an attorney must consult with certain people. For example, if you have an investment advisor who acts for the client, for the donor could say that with respect to the investments, there is a requirement that they consult with AB financial advisor, for example, in that. They could stipulate that certain people must be kept informed. You can, under the existing forms, and I'll talk about the new forms shortly, stipulate who the donor wants to have assess their mental capacity. With respect to benefiting the attorney, for example, if I was acting as attorney for David, and David, being the benevolent, kind person that he is, always gives me $1,000 for my birthday, for example, then that would need to be stipulated in the document that I, as the attorney, can benefit myself when I act for David, because unless that is stipulated, you cannot benefit or you cannot be rewarded for your services as acting as an attorney. With respect to successor attorneys, so again, if I was acting for David, if something happened to me, it's always recommended that there is a substitute attorney in place. So I end up in hospital or I pass away, then there would be the desired situation would be that I would be replaced, that there'd be a seamless transition, so that there was a successor attorney appointed. The making of a will, and under the EPA, it can specify that the attorney can make a will for the donor, but that's only if the family court has authorised that. With respect to revocation, unlike a will, an enduring power of attorney is not revoked if a new document is prepared. So there needs to be a formal notification that needs to be in writing, that needs to be provided for the donor, needs to be provided to the attorney from the donor. Obviously, the document is revoked or cancelled in the event of the death of the donor, or if the attorney gives notice of disclaimer, i.e. they state in writing that they no longer wish to act, or if the attorney goes bankrupt, or if the attorney passes away. The attorney, if they lose capacity, then the document is revoked. And again, as I mentioned previously, if there were joint attorneys, if one of those attorneys dies, goes bankrupt, or loses capacity, and the court revokes, excuse me, that is wrote, or if the court revokes the appointment under the legislation, which means that where they act jointly, they must decide to act together, whereas the attorney appointed severally can decide and act separately. So if it's joint, one party can't, or through circumstances is unable to act, then the other joint attorney cannot act, whereas if they are acting in joint and several, then the other attorney can act if the other attorney is unable to act or unwilling. The court can also revoke an enduring power of attorney. So why is it important for everybody to have an enduring power of attorney? As part of what you're providing for your clients, you're protecting, you're ensuring, you're assembling or enabling the clients to acquire and protect assets. If a situation arises where a documentation or some form of documentation is required by your client and through circumstances they can't sign it, what will they do? Where will they go? What recourse do they have? And I'll talk about that shortly. So what the enduring power of attorney is, it's another form of insurance. It's ensuring that there is that continuity, that there is the ability to access funds, to make the claim, to continue with the transaction, i.e. the mortgage application, the settlement of the purchase of the property. So there is that backup in place. It's, for want of a word, the fallback position, so that if something goes wrong, there's not that moment. There is that backup there. There is the ability to continue with the running of the business, for example. You know, if you've got SMEs as clients, they're in business, they are directors, they are shareholders, they're making the decisions, they're paying the wages. If they can't sign the checkbook or authorize the payment through the online system, who's going to do it for them? If, as I mentioned before, there's the living insurance claim, as an advisor, you are providing the protection for the client. Come claim time, that claim form can't be processed because the insurance company won't accept a claim signed by one of two joint owners or signed by the spouse of an owner. How does that make you feel? Who does your client look to for recourse? You know, what is best practice in this situation? So it's important that it is in place because it gives you, whilst you can, or the client, whilst they can, the ability to appoint or choose who will act for them if through those circumstances they are unable or incapable of doing so themselves. We often get suggested to us that enduring powers of attorney are for old people like me, whereas I would suggest that they're probably as important for young people, especially if they're tripping off on their OEs. We had the situation last year of a client whose daughter was over in Paris at the time of the Paris bombings. The daughter emailed mum, emailed the bank and said, "Help, please get money out of my account, remit it to me, I want to get out of here." The bank did not action that. They had no authority to do that. They were unable to act on mum's wishes. They were unable to act on the daughter's wishes because there was no enduring power of attorney for mum to transact that. So it is for all types of situations, all types of circumstances. So it's important that part of the toolbox of estate planning is the enduring power of attorney. So from a feature point of view, you determine, you choose who you want to act for you. With respect to court appointment, and again, as an example, I had a situation 2 weeks ago now where we had a client's family approach us. They had a situation where the father has become incapacitated, doesn't have the ability to manage and look after their affairs. They have a doctor's certificate to confirm this. They own 3 rental properties in their name. They have bank accounts in their name. They rely, or the family rely on that income as part of their living requirements. They don't, or the individual doesn't have an enduring power of attorney. We were asked to look into it. As a company, we can't make a court application. We engage with solicitors. So I rang our solicitor that we use. We were quoted $20,000 to do a court-appointed manager under the Act. So in addition to the cost, the time frame was a best guesstimate of 3 months if it was urgent, 6 months on a normal time point of view. So you can imagine the distress and the angst that is now causing the family because the rental properties aren't able to be managed, or the rent isn't able to be taken out of the bank account to which it's going into at the moment. Mum and the family aren't able to pay the rates, pay the mortgage. There's a potential mortgagee sale because there's no ability. The rent was going into a holding account and then being transferred across to another account to meet the mortgage payments. That has ceased. So there's all sorts of issues around not having them and when a court order is required. But I would always indicate to clients a minimum of $10,000 and 6 months to get a court-appointed manager. So the enduring power of attorney, it is a legal agreement. You can elect or decide what powers that manager has. You or the client can decide when it is appropriate for it to commence. It can be reviewed, can be revoked. And from a cost point of view, you're looking at an average cost of $150 to complete a document. So from a cost of $150 to complete, as opposed to a minimum of $10,000, it's an inexpensive exercise. So from a benefit point of view, clearly there is that peace of mind. There's the knowledge that come what may, there will be a backup, there will be an ability to maintain, to continue, to make claim, to ensure that the assets are protected. Flexibility, it can be adapted to suit the client's circumstance. And unlike a will, for example, you can have multiple property enduring powers of attorney covering different assets. So again, coming back to your client who's the business owner, he or she may want to appoint their business partner to have the authority to run the business if through circumstance or situation they can't do so themselves. So there could be a property enduring power of attorney limited to ABC Company Limited, then a further enduring power of attorney dealing with the other personal assets which could be in favour of the other spouse. Clearly, from a cost point of view, as I mentioned before, $150 versus potentially thousands of dollars, and there is that protection, there is the ability to continue things or to look after financial affairs in the event of an emergency.
Bryan, just a quick question. It's just come up. Somebody online has asked, would you normally prioritise an EPA if a couple were on a mortgage rather than an individual or just a single person?
So when you say prioritise, should both, if you've got a couple,
yeah, I guess the question is, if you were advising a couple, would you suggest that was higher priority, an EPA was higher priority for a couple than it was for a single person?
I suppose my simple answer would be everybody should have one. So if you look at the couple, if they were about to apply for the loan or drawing down a loan from the bank, both have to sign. If one can't sign, then potentially that whole process is thwarted. It won't proceed. If you've got an individual, same scenario. If that individual needs to sign the documentation, sign the paperwork, and if they can't sign, again, same scenario, the transaction may not proceed. So
this is, yeah, so we got, thank you for that, Nicole. That answered the question. Thank you, Bryan.
Right, so it's poll time, David.
Okay, so like our old system, we have various points throughout the session. We like to run a couple of polls, get people's views on what they do in relation to the topic in question. So today's poll, the first poll today is, do you ask clients about EPAs during your fact find? Now this should appear on your screen. Hopefully that should now be on your screen. And so the answer is no, sometimes, and always. So give it 10 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. And the poll, and let's just share the results, Bryan. I'm not sure whether you get to see what the results look like, but I'm sharing the results with the audience. I don't know if you can see that, Bryan. So 11% of the audience said no, they don't currently ask about EPAs during the fact find. 32% said sometimes, and almost 60%, so 57% said yes, they always ask about EPAs during their fact find.
Interesting, because the latest stats, or what stats we've been able to obtain, is that approximately 25, I think it is, % of New Zealanders have enduring powers of attorney. So it's very low. For want of a term, it's not out there. It's not something that people comprehend or understand. To a greater extent, but not to a satisfactory extent, people understand about wills and the need for wills, but I would suggest that enduring powers of attorney are as important as wills, because unfortunately circumstances do occur. As I somewhat black humour said before, the people that pass away, they are the lucky ones in that either they have a will or the law will dictate what happens to their estate. So there is a prescribed path to go down, whereas with enduring power of attorney, it's that issue of applying to the court, the delay, the cost, the frustration, and what that impact might have on the client in that. So just to move forward to the new changes to the legislation, and as I mentioned, and it was brilliant planning on David's behalf that he decided to do the enduring powers of attorney, because 16th of March there is an amendment to the Protection of Personal Property Rights Act. So I'll just go over these changes, what it means, with a bit of a caveat, and I say this because from a company's point of view, whilst the changes are good. We don't feel that they have gone far enough. What has prompted the changes, or what was the initial thought behind it, or the instigation of it, was around the abuse of the enduring powers of attorney, especially around elder abuse, where the son, for example, would be appointed as enduring power of attorney for mum. He would then have the authority. He would then go and misappropriate or use mum's funds. Under the appointment of a manager through the court, that manager is required to file in the court an annual statement of transactions, so basically saying what he or she has done as the manager, and then on a 3-yearly basis, that appointment is reviewed by the court as to its appropriateness. So what we would have liked to have seen is greater responsibility or greater accountability on the attorney nominated under the enduring power of attorney. But unfortunately, the legislation didn't cover with that, or they just kicked that can down the road. However, being positive, what they have looked at, or what they have done, is made changes with respect to the witnessing requirements, the witness certification, the requirement on the attorney to consult, the situation with respect to obtaining medical certificates or the certification around capacity, simplifying the revocation, and probably the most important thing is, and I'll talk about this later, is the new form. And that is a prescribed form. It's downloadable from the Ministry of Justice. So yes, you will potentially be able to do your own enduring powers of attorney, but no, there will still be the witnessing requirement. And then lastly, the new format is effective from the 16th of March. So any clients that are currently going through the process of completing enduring powers of attorney, unless they are fully completed by all parties by the 16th of March, that document will not be effective and they will have to start again. So if we just look at the changes as I mentioned previously. So the requirement under the new legislation, the requirement under the old legislation was that if, for example, a client, husband and wife, wanted to prepare enduring powers of attorney, they went to their lawyer could not witness both the husband's signature and the wife's signature. So one party would have to go and get separate advice and have their signature witnessed by a separate lawyer or a separate legal executive or employee of a trustee company. So what the new legislation is saying is that that same firm and that same lawyer can witness both donor signatures. So if the lawyer prepares the document for the husband and the wife, he can witness both signatures as long as, and this is the unknown, there is no more than negligible risk of conflict of interest. So what does that mean? And that's something that is very subjective. So certainly from our point of view, if we were dealing with a client's husband and wife or partners, and we knew their background, knew their history, and there was a current relationship, that's fine. But what if we had a client who was on his second marriage, the client was appointing his wife or appointing somebody that we didn't know about or that we also acted for? Is there a potential risk involved in that? So whilst we can witness the two parties' signatures, we have to assess that risk. And by letting the wife appoint the husband, knowing that the husband is a controlling person, for example, or that there is potential for manipulation or abuse, then we would still say to the parties that they would need to have that separate advice. But the objective is to simplify the witnessing. So if you have a couple, then the one person can witness both couples' signatures as donors under their respective documents. The witnessing certificate, there will now be a standard form of explanation. So the certificate that, for example, I as a witness will sign when I witness the donor's signature, there will be a standard form. So it will be a prescribed form as per the legislation, and that is the form that will be standard for all people now. That certificate that we have to give and put our signature to, we have to ensure and state on that the donor understands the nature of the enduring power of attorney, understands potential risks and consequences of the document, and is not under undue pressure or duress. So again, it is a subjective test that we would have to say and go through with the client to ensure that we are confident, that we are comfortable, that the son is not forcing mum to sign the document, for example, or that mum is not here because she's been badgered to do so and doesn't really want to appoint one, or the one that is appointed. So again, the onus and the responsibility is on the witness to ensure that the donor is fully aware, fully competent, and is as a willing participant, if you like, to the document. There are new requirements on the attorney to consult. So they have to consult regularly with the donor, and clearly this is about the appropriateness. If, for example, and again, taking my example of my mother, she has lost mental capacity. So yes, it's when appropriate, we would consult with her. But with due respect to mum, half the time she is not able to rationalise or to understand things. So it's not necessary, or it wouldn't necessarily be best practice in that situation. However, the attorney will need to consult with any person that the donor specifies. So there would be the requirement, for example, if I put in my enduring power of attorney that David, as my attorney, must consult with my brother. So there would be the requirement that he has to do that. There is also now the requirement that the attorney, property attorney, must consult with the welfare attorney or any other property attorneys that have been nominated, i.e. the substitute or the successor property attorneys. So there's the greater requirement for this consultation of that. And this is about informing, letting people know, or for want of a term, keeping the attorney on his toes so that he is required, or there is the attempt to lessen the possibility of abuse of the power. We mentioned before about the medical certificates and who provides them. There's now the removal of the option to select health professional to make the assessment of capacity. So previously, for example, you could have selected the geriatrician that you or the person was under as the person that must certify the mental capacity. So what the certificates going forward will be completed by will primarily be by the GPs. So there won't be the specified practitioner. It will generally be the doctor that the donor deals with going forward. As far as revocation, and I mentioned before that unlike a will, an enduring power of attorney is not revoked if a new document is made. So there's no automatic revocation. However, in the new form, there will be a tick box to say whether they wish to revoke the previous document that they have completed. So the donor will indicate if there's a prior document to be revoked. So that notice of revocation will be incorporated in the document in the new form. However, that potentially causes privacy issues because, for example, if under my previous enduring power of attorney, I had appointed David as my attorney, but for reasons best known to me, I decide David's not appropriate. I now want to appoint my sister in Invercargill, for argument's sake. I don't want to upset David. I don't want to let him know what I have done. If the individual just ticks that box to say that they have revoked, they will need to then send a copy of the new document to David as the revocation. So what clients may want to do, and what we will be recommending in those circumstances where they don't want the new information made available, is that a separate notice of revocation is prepared. So there will be two options: either revocation incorporated in the document, and then that total document then provided to the previous attorney as notice of revocation, or a separate notice of revocation which is then provided to that previous attorney. And as I say, depending on circumstances, whichever option is best for the client will be available for them in that. Okay, so the real change, and this is where it will impact on a lot of people and potentially on you as advisors, is that the new enduring power of attorney is a PDF online format. So it is, well, once it has been uplifted to the Ministry of Justice site, it will be able to be downloaded from the Ministry of Justice, and it will be a tick box, fill in the blank type form. So unfortunately, and as seems to be the want of government departments, we have received 3 versions of it so far, and the latest version that we looked at yesterday has changed from the prior version to that, and they have advised us that yes, the new form will be available, but it won't be available until the 16th of March. So very helpful, but at this stage, looking at the drafts that have been made available, it will be a very much paint by numbers, or follow the dot type form. It will be in plain English. It will be a matter of filling it in and ticking the options that are appropriate, i.e. whether you want a single attorney, a joint attorney, what conditions, what restrictions you may want to put in it. There are notes at the beginning and along the side of the form, and although they say, and I use plain English in inverted commas, the form, it will require some time to do in that. The options whereby they can elect for it to be effective immediately, or any conditions, any restrictions, they are incorporated. And as I mentioned before, the changes to the witnessing and the certification of the document in that. So I suppose that then comes back to the question of an advisor and what do you do? What is appropriate? Is it something that you would want to do with your clients? Certainly it's something that can be done at a at a level that doesn't involve professional advice. However, you've then got the requirement that it still has to be witnessed, and the witnessing restrictions are still there in that it has to be witnessed by a solicitor, a legal executive, or an employee of a trustee company. So is it appropriate, for example, that at underwriting time, the insurance company provides an enduring power of attorney? And certainly from an industry's point of view, that's something that we are looking at with insurance companies, whether that can be incorporated in the proposal, especially around any form of living insurance, or from a banking point, mortgage lending point of view, whether it's appropriate that a form be available at the time of the loan application, for example. But then what about the witnessing? You've still got the requirements for that downloadable DIY form to be completed, and then to be, sorry David, are you hearing me okay? I'm hearing buzzing in my ears.
No, your sound is fine, right?
Okay, sorry. Yep. Okay. So is it appropriate to complete that because the client will then need to go to get professional advice and then have that witnessing completed? So the options are to download and do it yourself, to go to your professional and have it witnessed, or for the professional to do the total package in that. And certainly, and from our point of view, if a client was to come into us today asking for us to witness that document, we would go through the full, complete process of checking, of verifying, of explaining. So subsequently, there will still be the cost for the witnessing, and that cost will be the same cost as the preparation of the document. So what's best? What's appropriate? And I'm not saying clients shouldn't do this, or that as advisors you shouldn't do it either, but there's still the need for that witnessing for that cost anyway. So that's a very quick and overview of the changes to the legislation. At this stage, David, the second poll is now up.
Okay, yeah, so we've got a second poll, which is, I don't know, it's very, very new news, I'm sure, to most people on the call today. But the next poll is based upon what you know about the proposed changes. Do you think advisors should take greater responsibility for ensuring their clients have EPAs? So let's launch the poll. And so the options are no, to just inform the client of the need, yes to using the Ministry of Justice template, or yes, and I guess perhaps being involved in engaging a professional to prepare. Hopefully that makes sense. So let's count down, give it another 10 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Okay, let's end the poll and let's share those results. So Brian, again, I'm not sure if you can see that, but the 21% said no, their view is that they should just inform the client of the need. 25% said yes, and probably get involved using the Ministry of Justice template with a witnessing follow-up. And 54%, just over half, have said yes, but they recommend that they would suggest engaging a professional to prepare it. It's interesting, interesting changes.
Yes, yeah. It's sort of, it's sort of a halfway house. And as I said, when I talked about or commenced talking about the changes, and that, yes, the witnessing will make it easier. Yes, the intent is good, but unfortunately, certainly in my personal point of view, is that they haven't gone far enough. There is still the risk around the appointment of the attorney. Who do you appoint? Who do you give that power to? At the end of the day, that person steps into the individual's shoes. Yes, they ultimately can be accountable through the courts if they are eventually found out or challenged, but what is that tracking? What is the measurement of their performance on an ongoing basis in that? And that's where the real issue is. And that, unfortunately, I don't think is what they have addressed with the changes to the legislation in that. Yes.
Yeah, that's interesting. And I do think, I mean, you raised some really interesting points, particularly around undue influence on the part of the attorney. So as I say, it looks like they've made some positive changes, but there's still some way to go to address some of the real challenges. So a number of questions come up. I'm conscious of time. We've got 10 minutes before we do it. So let me just wander through them. So Carol's asked the problem, or mentioned, and I think this is a very valid issue that many advisors experience when they're dealing with clients. The problem is not with asking whether they have an EPA. The big problem is getting clients to do something about it.
Yeah,
most people can't be bothered after going through all the insurance investment processes, and after a while, the advisor just has to give up chasing them because there's only certain things that you can lead a horse to water, you can't make it drink at the end of the day. So that's I think that's a challenge, and you mentioned 25% of only 25% of people have enduring EPAs in place. So that raises an interesting opportunity, I think, from an advisor point of view. I think that we may have mentioned this at the last session, the last one we ran, and at the moment, to encourage people to take out mortgages, for example, banks will often give an incentive. They might give some money towards legal fees or valuation fees. And I'm wondering whether there may be an opportunity here for advisors to extend the range of their services by saying, by taking out an insurance policy or taking a mortgage through me, one of the things that we will do is we will organise your EPAs and will. And we'll fund it up to we'll provide a contribution up to a certain amount. You obviously have to evidence the fact that you've used that money for the purposes of EPAs and wills. But I think that potentially is some value added there. Maybe that is the prompt to.
And just picking up your point, David, and rather than meet the cost, rather than not knowing whether the client will do it, perhaps like a credit note situation, and they could give the client a voucher which entitles them to seek and to have a will and an enduring power of attorney completed, for example, in that. So if there's, there needs, I agree, it's a carrot and stick. Yes, you can say all the scare stories and everything in that, but until there is that real, for want of a term, the rubber meets the road, people think, I'll get round to it, I'll do it one day, sort of thing in that. But it is real, and there needs, certainly, and this I mentioned before about insurance companies, and potentially banks, because this could mean loss of business for them as well, because if the transaction can't proceed, then there's no loan, there's no lending, the whole, it's almost like a stack of cards that all falls down in that. So for the want of the cost of $150, why wouldn't the bank or the organisation provide that or incorporate that in the cost of acquisition, for example?
As I say, it might well be an opportunity for advisors and enhance the sort of the relationship, and basically establish the advisor as a really trusted advisor.
It's that value add, David. It's a total ring fencing. Yes. Yeah,
exactly, and I think it's a real opportunity there. Carol's also asked, does the new legislation nullify any other form of EPA apart from the downloadable form?
No, simple answer. There is very dictatorial. It is one form, that's the way it is. You can't make any amendments, can't make any changes. It is in a prescribed format, and that's what it is. Any other document of any form won't be valid. So if, for argument's sake, I completed an enduring power of attorney on the 1st of April using our old form or our old template, any wise bank, insurance company or organisation, if they see it dated the 1st of April and they see it's not in the new form, they won't accept it. That is not a valid enduring power of attorney post 16th of March unless it is on the prescribed format. However, any enduring powers of attorney completed and fully signed and dated prior to the 16th of March, they are fine, but anything post 16th of March must be on the prescribed downloaded format from the Ministry of Justice. Yes.
Right. Okay. And are these forms going to be held in some form of register?
Again, unfortunately, not. Similar to like the wills, there's a no wills register, although there is a number of companies that are offering wills registry service. It's interesting because in the UK there is a register of enduring powers of attorney, whereas in New Zealand, no, there's not at this stage. And again, this is what we were suggesting as far as best practice, so that if an attorney has been appointed, then somebody can check to see who that attorney is, and can then, if anything is suspected of being suspicious, and then can make proper inquiries or make inquiries as to what is going on in that. Yeah.
Yeah, and then that would also manage the over sort of ones that are replacing old ones as well, wouldn't it? Would be.
Yeah.
Yeah. Interesting. Okay, a quick question. I think Michael's asked this question. What documentation is required to make welfare decisions when someone is on life support?
Well, the personal care and welfare enduring power of attorney would be effective, but if they're on life support, the personal care and welfare attorney can only act in the best interest with respect to health and well-being generally. So, for example, if there was a decision to be made regarding turning off the life support, for example, in that would generally be covered by a living will, because it's the standard medical procedure that is covered under the personal care and welfare. Like, for example, I break my wrist, I'm in a coma, my wife needs to give consent to the procedure to fix my broken wrist. That can take effect. Whereas if I was on life support, then I've made my wishes known that the switch is to be switched off, then that's separate. That wouldn't be the decision of the welfare attorney. That would be that life and death types situation and answer to whether you turn it off or continue with it in that.
Oh, that's interesting. I always assumed that the life support decision was part of the health and welfare.
No,
Yeah,
it's
no.
Yeah, because it's to maintain life under the personal care and welfare, whereas if you're turning the switch off, then you're potentially causing that life to end.
Right. Okay. So that would be that would then be presumably the decision between the next of kin and
the medical practitioners in that.
Yeah.
Yes.
Yeah.
Yeah, and based on also any living will which the individual may have made, whereby they have expressed what their wishes would be in that situation. Yes.
Right. Okay. I think one other question. 2 minutes. Once somebody's mentioned that I think we'll include the Ministry of Justice form in our lawyers' communication pack that we send to the conveyancing firm. I think that must be a mortgage advisor. Using the structure, and this will prompt the solicitors to talk about it, hopefully, which is a good point, actually.
Yes, it's very. It's interesting because we were talking. Well, I was talking to a colleague who was previously at another trustee company, and they weren't aware and aren't aware of these changes. So, with due respect to the conveyancing solicitor, they may or may not be aware. And yes, you could. Yeah, the mortgage advisor could perhaps be prompting that conveyancer to look at this, because with due respect to conveyancing solicitors, they specialise in conveyancing and don't necessarily deal with other aspects of the legal world in that. Yes.
Yeah, yeah. And there's just a final point about Perpetual Guardian's service. The EPAs, is that covered by the discount you offer to advisors? Or is there...
No, because that's a separate, because the discount applies to the will.
Right, okay.
Not for the enduring power of attorney. So there is that standard fee of $150 for the enduring power of attorney.
And just clarify, that's for each enduring power of attorney, isn't it? So you
that's
have
right.
two.
Yes, you have two documents. You have the property one and the personal care and welfare. Yes.
Yeah, cool. Okay, it's 11 o'clock, spot on, Brian. Your timing is perfect. Thank you very much for your insights this morning. Hopefully, listeners and viewers, that you found this of value. So the 16th of March, this new form comes into play. And potentially it's an opportunity for you to get in touch with your clients, your existing clients, just with this information and let them know what the changes are. And if your client base is like the majority of the population, you'll find that 75% of them don't actually have EPAs in place, and may well prompt them to do something about it. All right, guys, have a very nice weekend. The survey and reflections questionnaire will come through to you by email tomorrow. Any questions, fire them through to me, and then I will fire them through to Brian, and I'll try and get a copy of the presentation up online together with the video early next week. Have a great weekend, and we'll see you next time. Thanks very much.